Peter Stoma on behalf of the state.
Good morning, Your Honor. Charles, Chair for the state.
Good morning, Your Honor. Jeffrey Garrigan, the law firm of Camerata and Elton Garrigan, on behalf of Kelly Chesler, who's present for tomorrow.
Good morning, Your Honor. Robert Lytle from the law firm of Schaeferman Lakin, on behalf of Joseph Ascolese, who's present tomorrow.
Good morning to the defendants, Mr. Ascolese and Chesler. Please be seated. Ready to proceed.
Your Honor, having fully analyzed the remaining evidence in this case in the context of the court's October 12th decision under the State v. Reyes standard, the State has concluded that this case cannot be proven beyond a reasonable doubt. As such, the State is compelled to dismiss the remaining charges of the indictment against Joseph Ascolese and Lieutenant Kelly Chesler.
All right, without objection?
No objection.
All right. The court accepts the State's dismissal with prejudice. However, I do have to comment on the court would like to point out that it disagrees with the State's decision, or at least for its reasoning of its decision that it placed on the record. The State has indicated that it has made its decision to dismiss, and it rests upon the counts against these defendants in light of the reasoned decision that this court made regarding the Reyes motion or judgment of acquittal in favor of the defendant and co-defendant Michael O'Neill. First, Mr. O'Neill sits in a different position than the two defendants at bar. The court is not going to reanalyze the decision it made in Mr. O'Neill's case because the proofs, quite frankly, are all independent from each other. There are three separate and distinct trials occurring at the same time. In the O'Neill matter, the State had to prove that the defendant was not in a specific place when he has said he was. Thus, the State put themselves in a position where they would have to prove a negative. Proving a negative, though not impossible, is a difficult task. That is in contrast to the remaining defendants, Mr. Ascolese and Ms. Chesler, where again, briefly, in order to prevail on the charges set forth against them, the State would have to prove that they knew officers were not working their shifts when they were signing their pay vouchers. The court believes that this is a simpler task for the State to prove than it was for O'Neill. Second, and more compelling reason for the State to continue, the court believes, is that the State has not called what has been indicated to this court as their star witnesses. The State had planned to call a former co-defendant. It's important to note that these star witnesses would not have any effect on Mr. O'Neill's case. In other words, they would have not testified to the dates associated with Mr. O'Neill, but as a former co-defendant, this impending star witness, as the court poses, Michael Maietti, a former co-defendant on this indictment, could have testified to things that other witnesses would not have. The details of this alleged no-pay scheme. The court's Reyes motion decision for Mr. O'Neill spoke a lot about what is necessary to prove official misconduct. Before official misconduct can be proven or even committed, there needs to be promulgated rules and standards as our case law sets forth in State v. Crimes, 235 New Jersey Super 75, their appellate division decision, 1989 case. The court found that these standards these promulgated standards, at least with regards to the O'Neill matter, did not exist. If the State is basing their decision to dismiss the case on that alone, the court believes that their decision is misguided. Official misconduct is not the only charge levied against the remaining defendants. They are charged with theft, which can be proved without official misconduct standards. I just wanted to comment on that because clearly, and I know counsel all is aware, the proofs are all independent from each other. With that being said, this matter is dismissed against Mr. Ascolese and Ms. Chesler. I wish you all good luck. Thank you very much.
Judge, may I just briefly address one matter? Your Honor, my client's battle, so to speak, isn't over. She has an issue with the New Jersey Police Department. I would just ask the court, I know the court was very prompt in executing the judgments of dismissal with regard to Officer O'Neill and also the counts with regard to Captain Ascolese. So I would just ask if the court, if I need to submit a proposed order, something to make it quicker, because the quicker I get the court's order, the quicker I can go back to Jersey City and hopefully get her reinstated as a police officer.
I looked at my law clerk, could we provide them with an order this morning?
Yes.
You want to wait a few?
Absolutely. I don't wait, Judge. And also, Judge, on behalf of my client, I would like to thank the court for all its courtesies in this case. From beginning to end, my client has been treated like a human being in this courtroom at all times, and she's very much appreciative of that and very much appreciative of the court's time. I know it's been a very lengthy case from beginning to end.
We certainly echo that as well, Judge, and to the extent that we can get an order quickly, my client has been without a pension for a considerable period of time. That might expedite it.
We will do that forthwith, and I just want to note, every defendant that stands before me are always innocent until proven guilty, no matter who the trier fact. So I wish them both in their future good luck. Good luck with that.
Thank you.
Thank you.
Thank you very
Thank you. For cooperating.